Student reference 1810183, Arbitration Law BSM 601, Presentation Assignment 2018-2019. Good afternoon to the Tribunal. My name is Matthew Ray and I shall be representing the claimant Inverbervie and Senior Engineers Limited. I will now present reasons as to why the Tribunal is entitled to hear the dispute and that proceedings should continue to take place. The Kingdom of Zandu's own arbitration statute is an adoption of the United Nations Commission on International Trade Law, Model Law, on international commercial arbitration. Zandu is also a party to the New York Convention 1958. As the respondent may refer to, sectoral legislation in Zandu imposes some restrictions on the arbitrability of disputes, in particular disputes involving public corporations and other businesses with direct or indirect participation of the government or the royal family and resulting from public procurement. Now, referring to the arbitration agreement within the contract, we can clearly distinguish that there is a valid agreement to arbitrate. In case law whereby the validity of an arbitration agreement has been raised, just the mention of dispute settlement by arbitration has been deemed to be enough to warrant a valid arbitration clause. In case law judgment given in Lob Partnership v Aintree Racecourse 2000, among others, affirms this point. Arbitration need not be mentioned at all within the agreement within the contract. This was further discussed by Lord Justice Longmore in David Wilson Homes Limited v Surrey Services Limited 2001, whereby he stated, "There is no need for a clause which deals with reference of disputes to say in the terms that disputes are to be referred to arbitrator or arbitration." He goes on further to comment that from the present purposes, the important thing is that there should be an agreement to refer disputes to a person other than the court who is to resolve the dispute in a manner binding on the parties to the agreement. Further to this, we can also refer to Article 2 of the New York Convention, whereby each contracting state shall recognise an agreement in writing under which parties undertake to submit to arbitration disputes that are capable of settlement by arbitration. This arbitration can be defined as an international arbitration, as per the model law definition, as parties to the contract have places of business in different states at the time of the conclusion of the arbitration agreement. Depending on the nature of the contract, the agreement to arbitrate may touch upon a number of law systems that will govern the international enforcement. In this instance, we're faced with a client and a contract that is governed by the laws of the Kingdom of Zandu, the Hong Kong International Arbitration Centre, HKIAC, as known from now on, arbitration rules, being the rules by which the tribunal is required to apply, and the lex arbitri, or the law, being English law, as the seat of the arbitration is detailed as London. Relevant case law being Solamerica Kai Nacional de Seguros versus NSA Engahara 2012 outlined a three-stage inquiry regarding the law of arbitration agreement, with one of the points being if parties made an express choice of law to govern the arbitration agreement, that choice would be effective, regardless of the law applicable to the whole contract. The arbitration agreement states that the seat of the arbitration shall be in London, England, meaning we can clearly establish that English law and the Arbitration Act 1996 shall apply. The respondent is a business which is part owned by the Kingdom of Zandu's royal family and are party to a contract containing public procurement. In accordance with the legislation of Zandu State, this dispute should not be heard by the tribunal. However, inclusion of the arbitration seat being in London clearly shows that the arbitration shall be conducted in accordance with English law and the Arbitration Act 1996, and such restrictions are not contained within that Arbitration Act. The New York Convention, which the Kingdom of Zandu is party to, also maintains the reference to the law of the country where the arbitration took place and to the law of the country where the award is made. This continues the clear territorial link between the place of the arbitration, being England, and the law governing the arbitration, which is also English law. The usual practice under modern international rules for an arbitration tribunal is to decide upon its own competence. Article 23 of the UNCITRAL Rules, Section 30 of the Arbitration Act 1996 and Article 19 of the HKIAC arbitration rules all hand the tribunal competence to rule on its own jurisdiction. The respondent may argue the sectoral legislation in Zandu imposes some restrictions on the arbitrability of disputes and may raise this challenge under Section 31.1 of the Act. While the respondent may attempt to define the jurisdiction of the arbitrators, that jurisdiction is derived not from an international source, but from the arbitration agreement itself, which can confer only powers that are permissible under the law applicable to the arbitration agreement. Now, point 31 and Section 31.4a sets out that parties can agree for the tribunal to either issue a separate award on its jurisdiction or rule the jurisdiction or objection when ruling on the overall merits of the dispute. I would expect that the respondent will state it would be prudent to issue a separate award in case it is held that the tribunal doesn't have appropriate jurisdiction to hear the dispute. However, to do so will be uneconomical in the time to issue two awards when the merits are going to be ruled upon anyway. One award covering all matters, including jurisdiction, would be more sensible and would be in keeping with Section 1A on avoiding unnecessary delay or expense. Similar is stated in Section 45.4 of the Arbitration Act, whereby a challenge to determine the preliminary point of law, the tribunal may continue with proceedings and make an award while application to court is pending. Now, as per Section 32 of the Act, the court may, on application of a party to the arbitral proceedings, determine any question as to the substantive jurisdiction of the tribunal. It is quite clear that the respondent is within its rights to apply to the court for such. However, Section 32.4 is clear that unless otherwise agreed by the parties, the arbitral tribunal may continue proceedings and make an award while an application to court is pending. Now, as the seat of the arbitration is in England and that English law applies, any appeal under Section 32 must be made via the English courts. In case law Atlas Power versus National Transmission and Dispatch Company Limited 2018, it was held that the clause within the contract clearly stated the arbitration was seated in London and therefore any challenge to such arbitration award must be made through the courts of England and Wales. Finally, and as mentioned previously, the Kingdom of Zandu is party to the New York Convention, which applies the recognition and enforcement of arbitral awards made in the territory of a state other than the state where recognition and enforcement of such awards are sought. Now, it would be of little use and would go against the whole purpose of the Convention if an obligation to arbitrate in one country, as per the Convention and the contract, could be evaded by the respondent by commencing court proceedings within Zandu, the place of its location and the law of the contract. This convention operates through the national law of the state and represents a compelling force for unification of natural laws on arbitration. Refusing to arbitrate would completely go against that convention that the state is party to. The respondent and the state may also weigh up the political considerations, such as the effect that a refusal to arbitrate may have on relations with the state to which the claimant belongs. Whilst not wanting to offend the public policy by allowing arbitration to take place, refusal could lead to the loss of foreign investment and damage the state's reputation internationally. Due to the reasons set in this presentation, the dispute must be heard by the tribunal. Thank you.